A couple of days ago, something significant took place inside the Supreme Court that could potentially impact millions of immigrant families throughout America. And surprisingly, many people remain unaware that it even occurred. In early April 2026, all 9 Supreme Court justices gathered to address a single fundamental question that could determine whether children born on American soil to certain immigrant parents will continue to receive automatic citizenship. What might genuinely surprise you is that 6 of those 9 justices, including several appointed by conservative presidents, appeared highly skeptical of the government's arguments challenging birthright citizenship. The president himself attended this oral argument session, marking a historic first for a sitting president, and sat quietly for approximately 90 minutes listening to the proceedings. Based on the justice's questions and responses, what he witnessed may not have aligned with his expectations. This case carries enormous significance for specific groups of people. If you hold an H-1B work visa and your child was born in America, this directly concerns your family. The same applies if you are on an F-1 student visa, an L-1 visa, have DACA status, TPS protection, or if you lack documentation. Research indicates that hundreds of thousands of babies are born annually to mothers who are either on temporary legal status or without authorization, representing a notable percentage of all births nationwide. The executive order in question would potentially change citizenship determination for all these children. Let me explain the foundational details since considerable confusion exists around this topic. On the first day of the second presidential term in January 2025, an executive order was signed with the stated purpose of protecting American citizenship values. However, what this order actually accomplishes is instructing all federal agencies to cease recognizing automatic citizenship for babies born in America unless at least one parent holds citizenship or permanent resident status with a green card. Consider the implications carefully. If both parents hold H-1B work visas that the government itself approved, and their baby arrives at a hospital anywhere in the country, under this order that child would not receive American citizenship. The same applies to international students on F-1 visas whose baby is born during their studies, to DACA recipients who have resided here since childhood, to asylum seekers, TPS holders, or anyone with pending green card applications not yet finalized. Immigration experts estimate between 5.5 to 6.5 million people currently residing in the United States fall into these categories, with approximately 255,000 babies potentially affected annually if this order takes effect. Over 2 decades, that number could exceed 750,000 children. Here is the crucial point to understand clearly. This executive order has never actually taken effect, not even for a single day. The very first federal judge who reviewed it in Seattle described it using strong language indicating it was clearly unconstitutional. Every federal court that has examined this case has struck it down without exception, which is precisely why it reached the Supreme Court. Let me describe what occurred inside that courtroom because the proceedings were quite remarkable. Early that morning, the president entered the Supreme Court and took a seat in the front row of the public gallery. He was accompanied by the Attorney General and other administration officials. According to reporters present, he remained largely motionless for the entire 90-minute session, occasionally leaning forward or glancing toward the press section before quietly departing. During that time, here is what unfolded. The government's lawyer stood before the justices and argued that the 14th Amendment Citizenship Clause was originally intended only for newly freed enslaved people following the Civil War. He contended that children of temporary visitors and undocumented immigrants were never meant to receive citizenship, and that birth tourism represents a growing concern requiring the United States to align with countries lacking birthright citizenship. Then the justices began pushing back one by one. The Chief Justice, a conservative appointed by a previous Republican president, challenged the birth tourism argument directly, asking how prevalent it actually is. The government lawyer admitted uncertainty about the actual numbers. The Chief Justice then questioned whether birth tourism has any bearing on the legal analysis. And when the lawyer argued we are living in changed times, the Chief Justice delivered what may be the hearing's most significant statement. While times may change, the Constitution remains the same. A justice appointed during the first term of the current administration proved equally skeptical, noting that when the 14th Amendment was ratified in 1868, strict immigration laws did not exist, and anyone could arrive and establish residence. He referenced historical legal opinions that directly contradicted the government's position. Another justice emphasized that the landmark case establishing birthright citizenship had clear rationale based on historical tradition with no limitations attached. Yet another justice dismissed arguments about how other countries handle citizenship, stating that American law should be interpreted using American precedent based on American history, questioning why foreign practices should influence the analysis. This justice even suggested that following traditional precedent would make this a straightforward, brief opinion, which drew laughter from the courtroom audience. One justice raised a particularly concerning scenario that should alarm every immigrant family. She reminded everyone that when the Supreme Court previously ruled Native Americans could not become citizens, the government subsequently denaturalized people who had already obtained citizenship. She essentially asked what would prevent a future administration from applying such an order retroactively, stripping citizenship from children already born and recognized as citizens. The government lawyer indicated the administration intended forward application only, but notably did not state that retroactive application would be unconstitutional or impossible, leaving that possibility open. To fully grasp this situation, understanding a key historical case is essential. In the 1870s, a man was born in San Francisco to parents who had immigrated from China. Under laws of that era, Chinese immigrants were explicitly prohibited from ever becoming citizens, despite being allowed to live and work here. When this man traveled to China to visit family and returned, immigration officials denied him entry, claiming he was not a citizen. The case reached the Supreme Court, and in 1898, a landmark decision ruled him a United States citizen, affirming the fundamental principle of citizenship by birth within the territory, including all children born to resident non-citizens. This precedent has stood for over 125 years without any court overturning it or any president successfully challenging it. Significantly, the current administration admitted during arguments that it was not seeking to overturn this precedent, which legal experts called a fatal concession, since that precedent clearly establishes birthright citizenship. Let me address viewers directly now. Many watching likely hold H-1B visas, working at major technology companies, hospitals, or universities. The government approved your visa, you pay taxes, you contribute to the economy, and your child was born in an American hospital. Under this executive order, your child would not be considered American. To be specific about who is affected, if you hold H-1B, H-4, L-1, L-2, F-1, F-2, J-1, J-2, O-1, TN or E-2 visas, have DACA or TPS status, pending asylum, or an unapproved green card application, your baby born here would not automatically receive citizenship under this order. Something many people fail to realize is that immigration status does not transfer from parent to child at birth. If you hold an H-1B visa, your baby does not automatically receive that same visa. Currently, your baby is an American citizen, but under this order, your baby would be born without any status whatsoever. You would need to file separate paperwork seeking some visa category for your own newborn, and if denied, that baby could theoretically face deportation despite being born in an American hospital. One justice specifically raised this scenario during the hearing, noting that if allowed to take effect, the order could potentially separate newborns from parents who are lawfully present. Some children could even become stateless if their parents fled countries where registering a child with that government would be dangerous or impossible, leaving the child with no citizenship anywhere on earth. Based on the oral arguments, here is how each justice appeared to lean. At least 6 justices seemed skeptical of the government's position. The Chief Justice, and justices across the ideological spectrum who asked pointed questions challenging the administration's arguments. One justice asked probing questions of both sides, particularly regarding abandoned babies under the proposed rule, and seemed unsatisfied with the government's answers, making her position uncertain but potentially leaning skeptical. One justice focused questions on technical legal issues, making his position difficult to read. Only one justice appeared to openly support the government's position, emphasizing certain language in the historical precedent. The realistic assessment suggests at least 6 justices skeptical of the order, possibly 7, with one uncertain and one leaning toward the government. However, oral arguments do not always predict final outcomes, since justices often ask tough questions to test arguments rather than reveal their conclusions. The decision is expected by late June or early July 2026, and until then, the executive order remains blocked with no baby currently being denied citizenship. But what if the unexpected occurs and the court surprises everyone? Every baby born in the United States would no longer automatically receive citizenship simply by being born here. Every parent, not just immigrant parents, would need to prove their own citizenship or green card status before their newborn could be registered as a citizen. Currently, hospitals assist parents with birth certificates and social security numbers, processes that assume citizenship. Under this order, that assumption vanishes. A significant percentage of American births are covered by Medicaid, which requires a social security number for enrollment, which requires proof of citizenship. Without automatic proof, newborns could face delays in health coverage during their first days of life. Legal scholars have noted that if the court accepts the administration's legal theory, it represents not just a new rule going forward, but a declaration that the 14th Amendment has been misunderstood for over 150 years. Theoretically, even people already born and recognized as citizens could have their status questioned. One professor noted that if this interpretation were correct and her great-great-grandfather was a temporary immigrant, then she herself would not be a citizen. The positive news is that currently, today, the executive order remains blocked, and babies born in America are American citizens. However, preparation is essential. Here are 5 steps every immigrant parent should consider taking promptly. First, if your child was born in the United States, consider applying for their passport as it represents the strongest citizenship documentation. Second, obtain certified copies of your child's birth certificate from the state of birth. Keep originals secure. Create digital copies and store them safely as primary evidence of birth location. Third, ensure your child has a social security card establishing a federal record. Fourth, consult with a qualified immigration attorney rather than relying solely on online information, as every family situation differs, and an attorney can review your specific visa status and options if laws change. If private attorneys are unaffordable, contact legal aid societies or immigration advocacy organizations. Fifth, monitor the Supreme Court decision timeline and stay informed through reliable sources. Something receiving insufficient attention deserves mention. Even if the Supreme Court rules favorably for immigrants, which appears likely, damage is already occurring. Immigration attorneys nationwide report pregnant women afraid to visit hospitals fearing immigration enforcement presence. Parents are rushing to obtain newborn passports, terrified about government actions against their children. Families are making major life decisions about having children, birth locations, or remaining in this country based on fear of an executive order that has never been enforced. That fear is real and its effects are tangible regardless of the eventual Supreme Court outcome. My message to every immigrant family watching is this: document everything, protect your children's paperwork, stay informed, and avoid panic while also avoiding complacency. The Constitution currently supports birthright citizenship, and a majority of justices appear to agree, but preparation for any outcome remains wise. If this information helped you understand the birthright citizenship situation, consider subscribing and sharing with other immigrant families who need this information. I am Timothy from US Updates Hub. Stay safe, stay informed, and I will see you next time. Disclaimer: this content is for educational and informational purposes only. It does not constitute legal advice. Immigration laws are complex and individual situations vary significantly. Always consult a qualified immigration attorney before making any decisions regarding your specific situation.